Firstly, good evening, everyone. Thank you for giving up your Thursday evening to be here with us. And thank you, Ian, for the introduction. As Ian has kindly mentioned, my name is Natalia Rucka. I am a recent law graduate from the University of Aberdeen, and I have been working with Shared Parenting Scotland over the past 2 months writing this report, Learning from Abroad. And this report basically presents some foreign projects that aim to aid in family resolution using out-of-court options, yes. And basically, we're hoping to learn from these projects and hopefully bring them to Scotland. Now, before I begin, I would like to say this is my first presentation since about high school, so please bear with me. Hopefully by the end of this journey, you've learned something that you didn't know before coming here. The first step of this journey for this report is by asking the question, why are we looking abroad? And we can start answering that question by acknowledging the strengths of the Scottish family law system. So there have been positive changes that have come, and some of these include child welfare hearings, which have introduced an initial a move away from the initial adversarial procedure, and have helped us deal with disputes involving children faster. And similarly, the Children's Scotland Act 2020 has brought change in the sense of encouraging the inclusion of children and the expression of children in family law cases, as well as regulation of contact centres and child welfare reporters. Now, these are big positive changes, but if they fixed everything, I don't think we would be here today. So the main point is that these have not fixed all the issues. As Edward expertly spoke of already, he has highlighted some of the issues that are present. But on top of these, in just the short time that I'm out of university and have started looking into the family law system, I've found that dissatisfaction seems to persist threefold. Firstly, amongst parents, there is shock at how slow and unpredictable the system is. Amongst the judiciary, there is a waste of time and resources with cases that shouldn't be in court. As expressed by the president of the Family Division of Courts in England and Wales, 20% of family disputes don't belong in courts. But amidst this adversarial process and delays, it is the children who end up forgotten. Now, I am speaking from quite a privileged position. I did not grow up with separated parents. But the reason I am interested in family law is I wish to dedicate myself in improving people's lives, and I suspect many professionals that are here today feel the same. And I think to start with that, we start by acknowledging there is a need for change. The changes come in the form of moving conflict out of the courts, providing early resolution options, and quick and affordable support for separating parents. And this will all be to ensure that the children are at the very center, always. So we find that similar problems happen worldwide in family law systems. But the key difference between these and Scotland is that they are engaging with change. In just some of the projects we have looked at, there are already some key benefits. Some of these include empowering people with technology over the process, improved non-legal knowledge, people-oriented solutions to problems, amongst many more. If we're seeing these fantastic benefits happening abroad, the question changes from why look abroad to why not Scotland? Now, in this report, we have included 9 different developments and 6 different countries, but I wouldn't want to keep you all that long, so we're going to focus on just 3 today as a basic kind of introduction. But if you are interested in this topic and you would like to read about it more, we aim for the report to be published next week, so keep an eye out for that if you are interested. So we're going to start with the first one, which is Utelkar. Utelkar is a project happening in the Netherlands. So what is Utelkar? It's quite an innovative, different approach to family conflict because it uses technology to simplify and personalize the process. It is an online dispute resolution platform. So how it works. It's quite simple, which I'm sure isn't quite obvious from the slide, but it is simple. The first step is that parents register. They pick a plan that suits their specific situation, which can either be a parenting plan, a divorce plan, or parenting and divorce plan. They then both fill out a questionnaire. And this takes about 20 to 30 minutes and includes some fundamental questions about housing, children, assets, but it also takes it further and it asks quite positivity and children-focused questions, such as, what was your partner good at? Or what do you value most about the way your partner interacts with your children? Really trying to change the mindset that parents go into when it comes to divorce. So once they filled out this questionnaire, the website provides templates for arrangements that the parents have agreed on and options for those that they have not. And within this platform, parents can communicate, they can access extra services such as child maintenance calculations, alimony calculations, as well as mediation services if they are struggling to agree. The mediation does come at an extra cost, but I will discuss that later. And most of all, they have unlimited access to a case manager. And this can be online or over the phone. So once both parents agree on a final version of the plans, and once the case manager is happy with these, that's when we move on to the second step of the process. And that's when the lawyer comes in. Now, the lawyer checks over this plan and it makes sure that it's fair in the sense of there is informed consent, it is balanced between the parties, it is legally valid and practically executable. This review may go back and forth a few times until the lawyer is satisfied that the plan is fine. And then a one-time meeting is arranged between the parties. And again, this can be in person or online. Then the plans are signed and submitted to the court. Now, the third step is simply a formal step. The Netherlands are different from Scotland in the sense that parenting plans are mandatory. So this step, again, is necessary just for the formalization. But no hearing is needed. Just need to be submitted and accepted by the court. The aftercare is an additional step for parents who want to discuss the formalization and potential future changes that may affect the agreement, as well as gives them the opportunity to feel supported and ask questions. They can use the services again that are provided on the website, on the platform, and even submit further documents to the court if required. And here we have just a demonstration of the process. Now, the catch, what does this all cost? But in fact, it is better than you think. Parents start with a 5-day free trial of the platform. And after those 5 days, all they have to pay is 25 euros for the preparatory stage. And this includes unlimited use of the platform. Now, it is an extra price for the mediation to be included in that. And as you can see on the slide, the prices of the plans. There are, however, subsidy discounts available, and these come down to as low as 38 euros per person for each module and 21 euros per person for the mediation. So court costs and other service costs are excluded, but child maintenance is included with the child maintenance calculation is included in the parenting and divorce and parenting plan. And despite these prices, these are fixed fees. Still the most affordable option that is available in the Netherlands. So the main question is, why should we choose Utelkar? Why are we considering Utelkar? And some of these important points, I think, demonstrate exactly why. If we're looking at the 2020 to 2021 impact report, the first bullet point there demonstrates just how big an impact this platform has had. For every €1 input, it has created 5.8 social return, as well as other benefits, including empowering people with technology, giving them the comfort of working at their own pace and within an environment they feel safe and comfortable. It also takes away the stress of money adding up with fixed fees and only paying for what you need. But also, it offers a hybrid between online, offline, so it's digital, but with real people. And of course, the extra reflective elements using positive psychology. So we move on to our second, which is the Early Resolution Project in Alaska. Now, this project is quite drastically different in that it is a procedural change within the system. So this project mainly aims for select family law cases that would otherwise be self-representing and provides them with access to legal assistance and mediation that is free and unbundled. This was introduced due to the high levels of self-representing litigants within Alaska. And as I'm sure many of you are aware, that also seems to be the case in Scotland. Again, considering how this works, this is a bit different. It is a 3-step process. Firstly, there is the screening step. Within this step, a case is filed, and within that 1 day of filing, it is transferred to the Family Law Self-Help Center. And there, a staff attorney reviews whether the case is suitable for the Early Resolution Project. And this is reviewed twofold. Firstly, it is reviewed that there are 2 self-representing litigants. And secondly, it is screened against other factors that would otherwise exclude it from the program. They would mark it as a complex case and would exclude it. And factors include domestic abuse or a relocation issue, or if there's a special needs child that requires expert testimony, amongst other factors. If selected, however, the staff attorney schedules an Early Resolution Project hearing within 3 weeks. Notice is sent to the parties, along with information and advice and a contact number if they were to have any more questions. On the day of the hearing, the parties are assigned either 2 volunteer attorneys, a mediator, or settlement judge. And this will all depend on the issues within the specific case. Depending on those issues, no attorney or mediator may even be required. Now, the judge at the hearing acts as a settlement judge. That means he or she works directly with the parties to find a solution to their case. Once the judge is satisfied that there is a solution that works, the documents are prepared in court, they are signed, and the case is closed by the next day. And again, you can ask, why the early resolution project? Now, I think the results of this evaluation speak quite highly of why. We've seen quite drastic results in that the early resolution project is 3 to 4 times faster than regular cases. It requires 39% fewer steps. Each case saves 13 hours. 80% of cases are resolved in up to 3 hours. So ultimately, ERP involves faster resolutions, less staff time, less steps, while maintaining similar levels of satisfaction with outcomes, which I think is quite drastic. But if that's not enough, we can also take in the developments since the pilot, in that it has been institutionalized and expanded to the 3 courts in Alaska with the highest caseloads. And also other benefits can include the fact that people have access to early resolution, they have interim or child support orders issued. The screening process does not actually weigh heavily on the family conflict or the party's position on the issues. That is recognized as more of an outcome of the adversarial process and not seen as reliable indicators of what actually the parties wish for. It also addresses many difficulties of self-representing litigants, such as tension on the court's neutrality, and provides lawyers with discrete opt-in pro bono, which only requires responsibilities for as long as the hearing lasts. No preparatory work before, no follow-up required either. And lastly, reflex. Again, this is very different to previous 2 projects in that it is a series of training courses that are happening in England that provide knowledge on emotional and psychological issues in family law cases. It is unique in the UK, one of its kind, and for all those involved, not just lawyers. So there are 9 of these courses, and they launched in 2022. As you can see on the slide, it's understanding the impact of conflict on children, listening, the art of effective questions, boundaries, the importance of language, child development, dealing with conflict, the dynamics of relationships, and attachment and systemic theories. Courses 1 to 6 are already available, and 7 to 9 should be available by October this year. For those interested, if you complete all 9, you will have a certificate in essential skills, and a further diploma with further learning is in development. Now, all of these courses are a mixture of pre-recorded webinars, exercises, quizzes, and involve a reflective element, meaning they require you to look back on your own experience and they remind you what it was like to be a child once too. Now, Leo Yoons provides the psychological components to the courses. And a platform is also in development that provides people the opportunity for feedback, questions, and support. Again, costs. The costs of these courses are £114 with the opportunity to pay for a bundled discount of £300 for the first three. Again, why Reflex? What would Reflex give? And while Reflex provides comprehensive knowledge that can be used by anyone within the family justice system, I believe this particular for lawyers. It provides you with an understanding of your client relationships and create long-lasting settlements. And the best thing is, it can be brought into Scotland now. Now, if that hasn't convinced you enough, there has been some really positive feedback brought to Reflex from people who have already completed the courses. And one I would like to bring your attention to particularly is the one that should just be on the right now. Specifically, it says, I love the idea of ending on hope. Being able to be confident and advise clients that there won't always be conflict and that a future holds new possibilities. It is a very useful tool. I'd like you to keep that in mind. So, to recap, there have been positive changes brought to Scotland that cannot be denied, but they have not been enough. We can learn from developments happening abroad, and we can see how they could benefit the Scottish system. The three we have looked at today is Utilcar, Early Resolution Project, and Reflex. But if you are interested in the other six, the report will be coming out with those. I think by now I've made it quite clear what the benefits are. I'm sure you're very much aware of those. So if there's one thing I would like you to take away from this presentation, ending on hope, is that I need your help. I cannot cure the Scottish family law system on my own. But change is possible. And we can push for change together. So if change is happening in Scotland, abroad, let's make it happen in Scotland. Thank you.